Good morning, America. Good morning, Wisconsin. Good morning, the great Midwest cities, towns, and villages throughout our area. This is Jim Santel, and this is Morning Cannolis, coming to you from WAUK Radio, the Shaw in downtown Waukesha. I'm here at the studios, 540 AM, 101 FM. Connor is my producer this morning, joining me also in the studio this morning. Looking forward to 2 full hours of discussion, of engagement, and also taking your questions, your comments, your thoughts along the way at 844-967-2789. Morning Cannolis, a weekend review of the important stories in law and government and the aspiration for justice in America. We've got a very ambitious but achievable agenda this morning, a syllabus that returns in many ways to our previous discussions of previous weeks about the United States Supreme Court. And this morning we're going to be finishing up the arc of matters, of discussions on a variety of different cases that the Supreme Court has decided recently. And the next week moving on to a whole new arc, again focusing on law, government, and justice in America. Before we get all to that, let's talk about Saturday, July 9th. July 9th, it's the 189th day of 2022. A number of very important things happening on the 189th day of the year, July 9th, throughout history. 1776, the Declaration of Independence is read aloud to General George Washington's troops as he is in New York City. 1789, across the Atlantic Ocean, the French Revolution getting underway. The National Assembly declares itself the National Constituent Assembly. 1853, Commodore Perry from the United States brings his 4 U.S. Navy warships into Japan, opening up that nation to Western influence for the first time in American history, including international history, certainly the history of Japan as well. 1868, Louisiana and South Carolina become the last states in the Union to ratify the 14th Amendment to the Constitution. Just as an aside this morning, as we begin our discussion, the 14th Amendment, all persons born or naturalized in the United States, subject to the jurisdiction thereof, are citizens of the United States of America and subject to the laws and Constitution of it. No state, the 14th Amendment says, shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any such person within its jurisdiction the equal protections of the laws. 1868, the final ratification of the 14th Amendment, huge event in American history. We celebrate that today on July 9th. 1877, the first ever Wimbledon tennis championship begins in England. And then in 2017, a significant issue again in international affairs and international history. Iraqi Prime Minister Haider al-Abadi declares victory over the Islamic State in ISIL in northern Iraq, in Mosul. That's a victory over ISIL after several years of war and devastation, northern Iraq and the western portion of Syria. So an important day in history, July 9th, the 189th day of 2022. Again, welcoming you to Morning Cannolis, our sampling of news desserts of the week. As I said before, we're going to chat again today, bringing to a close our arc today on this 5th program of our series of Supreme Court cases, inviting your comments, your questions as well at 844-967-2789. A bit of history going back recently. We know that in recent weeks, last week in June, last days of June, the United States Supreme Court issued a number of very, very important landmark cases. Dobbs versus Jackson, Women's Health Organization, holding that the Mississippi law that banned abortions after 15 weeks is in fact constitutional, and overturned along the way the constitutional right to abortion that was established by the Supreme Court in 1973 in a case called Roe versus Wade. No longer good law in the United States of America. A very significant case happening on June 24th, just days ago, in the lifeblood of our nation. A 6-3 decision coming out of the High Court. A day earlier, again, a 6-3 decision on June 23rd in a case called New York State Rifle and Pistol Association versus Bruin, coming out of the state of New York. The High Court ruling that states with strict limits on carrying guns in public violate the Second Amendment to the Constitution. Again, a lot to unpack there. Basically determining that New York's particular codification that required an assessment of whether or not the particular applicant was qualified to hold and carry a weapon in public, that could no longer stand, affecting many other states, affecting generally our understanding of the Second Amendment, and having an impact because of the way that case was written on the assessment that will probably be given to future laws and regulations with respect to guns in America. Again, a 6-3 decision on June 23rd. And finally, the other one we talked about in recent times together, Saturday mornings, June 21st, Carson versus Macon. Carson versus Macon, again, a 6-3 decision of the United States Supreme Court. What did the court hold there? The court found that a Maine program coming out of the state of Maine that excluded religious schools from a state tuition program violated the free exercise of religion. Parents seeking to send their students, their children, to schools that have a religious education could in fact and should in fact have access to state monies when in fact the state is not providing public school access in rural portions of Maine. Again, a very big case involving free exercise under the First Amendment. We're going to be revisiting that again today in the discussion just ahead because religion continues to be a huge issue before the Supreme Court, and a couple of cases also decided, even since Carson versus Macon, that are going to impact our understanding of the First Amendment, freedom of speech, freedom of religion in America. So once again, a very brief primer of what we have done in the past on those particular cases. Today, I want to go back and begin our discussion of Supreme Court cases by visiting a few other cases that the Supreme Court also decided. We've made some reference to them in the past, but also significant to understanding what the Supreme Court has done. And then, most of our discussion this morning into the first hour, into the second hour, focusing on 6, maybe 7 major cases having to do with immigration and climate change, and yes, once again, religion. We're going to talk about non-Indian prosecutions of offenses on Indian lands. We're going to talk about Miranda. We're going to talk about the death row this morning, all cases coming out of the United States Supreme Court. And then at the conclusion of our second hour this morning, Morning Cannolis, we're going to talk about the next term. Yes, the Supreme Court does have a next term coming up starting in early October, the first Monday in October, talking about cases that are already on its docket having to do with legislative capacity to make decisions about elections in America. Very interesting case. We'll chat about that. The fight, if you will, the problem between LGBT rights and religious freedom, that issue coming up on the Supreme Court's docket. Race as an admissions aspect and an admissions consideration for our universities and colleges, and also another environmental case under the Clean Water Act. All that coming up in the next term of the Supreme Court. We'll chat a little bit more about those cases at the end of our second hour this morning. Inviting you to join me here on Morning Cannolis, calling in with your questions, your comments at 844-967-2789. I promised a moment or so ago that we'd visit a couple of cases from the Supreme Court way back in March and into the early months of this year that also are important to understanding what our nation is all about and what we're doing these days in connection with the death penalty and religion in particular. This case is called Ramirez versus Collier. In this particular case, the high court ruled, this time by an 8-1 majority, only Justice Thomas in the minority in this particular case decided on March 24th of this year, going back several months. The high court finds that Texas would violate a federal law protecting religious freedom, the Religious Freedom Reformation Act, if it executed a death row inmate without allowing his pastor to touch him, to lay hands on him prior to that execution. A grisly set of circumstances, but affirming once again of the Eighth Amendment that under circumstances established by the Supreme Court, capital punishment is still a possibility in states in America. And this particular case not only affirming implicitly that Eighth Amendment opportunity, that option, that legislative option for courts, but also affirming here the right of a inmate on death row to tell the people who are going to put him to death there in the state of Texas that he does in fact have the right to have his pastor touch him and pray aloud during the course of that grisly procedure in the execution chamber. So again, a dark case factually, but important in terms of religious freedom in America. That's Ramirez versus Collier. Another case coming out of the Supreme Court, this one in March of this past year, a case called United States versus Zubaydah. The court ruling there that the government was not required to disclose the location of a CIA black site, a place where the CIA was doing what's called extraterritorial renditions, where a detainee in Guantanamo Bay had been subject to waterboarding. That case brought by the detainee in Guantanamo Bay, a fellow named Zubaydah, challenging the United States in connection with his continued detention, wanted to find out more about the circumstances of his detention, happened to be in Poland at the time, and the United States Supreme Court says that by a vote of 7-2, only Justices Sotomayor and Justice Gorsuch in the majority, that the government was not in fact required under the state secret doctrine to disclose the location of that particular location there in the country of Poland. That's Zubaydah versus United States of America. We're going to take our first break today, and then we're going to come back, talk about a couple more cases, and then launch into the major new cases since the time we last got together here on Morning Cannolis, talking this morning once again about Supreme Court cases, the things that define us, the things that define our life, our livelihood, and the jurisprudence in the United States of America in 2022 and beyond. Join us here at WAUK Radio, the Shaw and Waukesha, 540 AM, 101 FM. And we're back. This is Jim Santel joining you this morning. Thank you for joining me. Connor is also with me in the studio here at WAK Radio in downtown Waukesha. It's the Shaw 540 AM 101 FM. Also taking your phone calls at 844-967-2789. This is the fifth in our series of discussions, of presentations, of engagements on the United States Supreme Court and what it has done in this past term. In the first segment today, we talked a bit about some of the landmark cases coming out of that court, and finishing up here for the next few moments on a couple of other cases from earlier this year that also animate who we are and what we're going to be as a nation. You may recall well that former President Donald Trump had attempted to block the release of some documents concerning his role in the events of January 6th of 2021 on the executive privilege theory, those grounds. And in a case called Trump versus Thompson, the name of the chair of the January 6th committee, Benny Thompson, the United States Supreme Court ruled way back in January 19th, 8-1, with again only Justice Thomas in the minority. The Supreme Court rules that former President Trump could not block the release of those White House records to that House committee investigating the January 6th attack on the Capitol. We're going to be talking, of course, more about January 6th this coming week as they have two more hearings. But again, a very relevant case, finding that executive privilege did not prevent the disclosure to that committee of these documents from the administration of President Donald John Trump. And that was, again, Trump versus Thompson. Yet another case that, again, you probably remember well from this past term. This one also in January 13th. This one 6-3, right down so-called ideological lines. the so-called conservative blocs voting in support of this result, the so-called liberal bloc voting in opposition to it. A case called National Federation of Independent Business versus Department of Labor. A very long title. This is the vaccination case. The High Court finding that the Biden administration, the attempt by the president to impose a vaccine or testing mandate for large employers, large companies, more than 100 employees, that was not lawful, that the president did not have the executive authority to enter that, made some accommodations when it comes to some particular healthcare workers at facilities receiving federal monies, but with that notable exception, a 6-3 decision turning back the president's attempt to impose a vaccine on companies of more than 100 more employees. That again back on January 13th, a 6-3 decision. Again, very important in understanding this relationship between the court and the executive branch. So a brief analysis, a brief review again of some of the major cases from the early months and then the most recent days of this term. We're taking your calls. We're going to begin this morning with Mark. Mark, we appreciate your calling in. What's your comment, your question, your thought here on Morning Cannolis?
Yeah, it's interesting that, and thanks again for taking my call. It's interesting that the Supreme Court is ignoring precedent in some of these cases. The separation of church and state issue that they ignored in the decision. And I had to look this one up. I remember that, from history class, Jefferson's letter to the Danbury Baptist Church, saying that because they were concerned about being oppressed by the Congregationalists, the Baptists, because there was a lot of religious oppression in our days as the colonies, and that there is actually there actually is, that the court had, in the 19th century at least, and they had the date. I saw the case there. I wasn't familiar with it before, but Reynolds versus the United States of 1879, saying Jefferson's writings on the First Amendment can be taken as what he actually meant when they were writing the Bill of Rights, and how that was should be interpreted. That. Because it is interesting, you read some good historical fiction. There was a missioner had in his book Chesapeake wrote of a and he may have drawn this from history, of a judge that impregnated his bondservant and had her whipped for being pregnant out of wedlock, and then awarded himself custody of the child when the child was born to be his bondservant. I mean, that's the kind of abuses that our courts had in colonial days. I mean, that's
sure.
The case.
And a lot of those things, Mark, that you're chatting about, we're going to chat more about, specifically in connection with prayer. I suspect that may prompt your phone call already this morning. We'll chat more about this case called Bremerton, Kennedy versus Bremerton. We'll chat about that. We'll chat about one more case involving a death row inmate a little bit later on in the program as well. So appreciate all those insights on religion in America. I think you're right that the Supreme Court plainly wrestling with this. Virtually all the cases, as you're indicating, Mark, of recent times in which the Supreme Court's wrestled with the Establishment Clause, the Free Exercise Clause, religion has almost always been the victor, been the successful party, and we'll talk more about that during the course of our time this morning. So, Mark, appreciate your insights and your perspectives, and we'll invite you and others to stay tuned for our further discussion in the next hour, and perhaps in the second hour too, talking more about school prayer, talking more about the intersection between religion in America and our lives on a regular basis. I want to get back to some other matters that the Supreme Court has also taken up, even since we were together right before the break for the Independence Day holiday. We provided some basic information about the background on some of these cases, but since that time, some major rulings by the United States Supreme Court, not always majorities, not always even that is unanimous majorities, not even close. And this is one of those, a 5-4 majority. The Supreme Court ruled right before the Independence Day holiday that the Biden administration could in fact turn back could rescind a Trump-era immigration policy that forced asylum seekers coming to this nation, seeking asylum from their nations of origin, keeping them awaiting approval or some administration of their candidacy for admission into the United States of America, keeping them in Mexico, sometimes called the Remain in Mexico policy. Chief Justice John Roberts, on behalf of a 5-4 majority, said an immigration law gave the president discretion to return migrants arriving by land into the country from which they came. But that discretion did not amount to an obligation, he significantly said. He went on to say that the use of the word may rather than shall means what it says. May means may. And said that making removal mandatory would require ordering the president to negotiate with Mexico. Very interesting language from the Chief Justice. Judges should not lightly interfere with the president's ability to conduct foreign policy in a holding that plainly was recognized and appreciated by many human rights lawyers and advocates. And so once again, that case called the Remain in Mexico case, a very important case in our nation's history. We'll talk more about that and other matters coming up in the next segment here on Morning Cannolis. And we're back. This is Jim Santel, Morning Cannolis. Thank you for joining me. Thank you for joining Connor, also here producing the show this morning in our studios of WAUK Radio, the Shaw in downtown Waukesha, right here on Wisconsin Avenue. A beautiful, gorgeous morning here in Waukesha. This is 540 AM, 101 FM. Also taking your phone calls at 844-967-2789. This is the last in our series of 5 discussions about the United States Supreme Court, the term just completed in recent days. Right before the break, we're chatting about some of the very recent cases, decisions, opinions handed down by our high court, including this case called Biden versus Texas, this Remain in Mexico program that the Supreme Court said that the Biden administration could rescind, could return that back to its administrative shelf, if you will. The challenge program, the Remain in Mexico program, more officially referred to as the Migrant Protection Protocols, had applied under the Trump administration to people who left their country of origin, a third country, traveled through Mexico to reach the United States border. And as I said before the break, the policy was put in place at the beginning of 2019. In the wake of that, you may recall a lot of the news coverage of this. Literally tens of thousands of people waited in unsanitary tent encampments for immigration hearings, again in Mexico, thus the name of the policy. There had been widespread reports of sexual assault, kidnapping, torture. The Biden administration comes into office and attempts to rescind that. Challenges brought by the states of Texas and Missouri. Ultimately, the Supreme Court says, nope. The president does, in fact, have the prerogative under the law. The Supreme Court's not going to get involved in this kind of a matter that would involve the negotiation with a foreign country. Writing for a majority, a 5-4 majority, the Chief Justice affirms the capacity of the president to turn back that policy, to turn it back to the way it was before the Trump administration policy. The Chief Justice is joined in that decision by Justice Brett Kavanaugh, and then also by Justices Sotomayor, Kagan, and Breyer. Again, that's a 5-4 decision, June 30th, Biden versus Texas. At about exactly the same time, a second major case that has implications well beyond just its particular facts. This is a case involving the environment and in particular climate change, the future of our nation, the future of our world. The Supreme Court finds that the Environmental Protection Agency's ability to regulate what are called carbon emissions from power plants, making it much tougher for the Biden administration to achieve a goal of cutting greenhouse gases, that decision, that rule entered by the EPA cannot stand. And that the rule entered by the EPA, that administrative decision, is in fact unlawful. This is a decision of 6-3 in this case involving the EPA and the question of admissions, obviously an attempt by the Biden administration and by the Obama administration. That's when these rules are first put in place to address greenhouse gases, to impose through the agency some requirements for these large power plants that are in fact polluting the air and causing some of the issues related to climate problems in our world. And so what does the Supreme Court do with this? Well, the Supreme Court, again, 6-3, a 6-3 decision, finds that, in fact, the EPA does not, in fact, have that authority to make that kind of a decision, and turns the rule back. Chief Justice John Roberts, writing for the majority, basically glancingly alludes to the harms caused by climate change and basically says that the administration through the EPA does not have this authority. The implications of this, of course, could extend well beyond just environmental policy. And it also signals, as we'll talk in just a moment from now, the court's expanded view that's being very skeptical of the power of administrative agencies to address some of the major issues facing the nation and our planet. The Clean Air Act, the Chief Justice writes, does not permit the agency to do what it established, what it's trying to do. He says that Congress has not clearly given the agency the sweeping authority it needed to regulate the energy industry. He says capping carbon dioxide emissions at a level that will force a nationwide transition away from the use of coal to generate electricity may be a sensible solution to the crisis of the day, but, he adds, a decision of such magnitude and consequence rests with the Congress itself or an agency acting pursuant to a clear delegation of that representative party. That's the Chief Justice writing on behalf of the 6-3 majority in that very important case involving greenhouse gases and climate change. Needless to say, there is a response from the other side. Justice Kagan and others are right that the statute of issues in the case has given the agency ample authority to do this. She says the Clean Air Act was a major legislative piece. It was designed to deal with a major public policy issue. Congress knows what it does and doesn't do, and it knows when it can act, knows when it can act, and it understands also when it drafts a statute the kind of authority that's given to the executive branch. Justice Kagan, again, writing on behalf of the minority, says that Congress, therefore, does give an expert agency like the EPA the power to address exactly this kind of thing, even significant ones like this, when they arise. So again, a strident view in opposition to that. She goes on to say that this is not the Attorney General regulating medical care, which is the vaccination case, or the CDC regulating landlord-tenant relations having to do with the moratorium. She says it's the EPA, that's the Environmental Protection Agency, in case the majority forgot. This is, again, Justice Kagan writing this, acting to address the greatest environmental challenge of our time. The consequences of this, as I indicate, are huge, not only with respect to the capacity of the executive branch to pursue avenues and efforts to address climate change in our nation, but they arguably go much beyond that, because it signals, again, this attempt by the Supreme Court to turn back some of the traditional administrative capacity of agencies like the EPA and others to act on behalf of the American public. Many people have looked at the majority opinion and said basically this, that as the Chief Justice has described it, if it's something that's big, if it's grandiose, if it changes the way that we think about policy in America, And it's new. It's new. It's not something that an agency has done before. If it's big and it's new, it probably is not going to survive muster by the United States Supreme Court. Has great consequences for the future of the administrative relationship with the Congress. This case, called West Virginia versus Environmental Protection Agency, decided on June 30th, just a few short days ago, a 6-3 majority, again, right down ideological lines. The court's ruling, again, curtailing the EPA's ability to regulate the energy sector, imposing these greenhouse gas emissions limitations, and finding that only Congress, a legislative branch, can engage in that kind of rulemaking through the legislative process, the executive power, the executive branch, the White House not having the authority to do that. Again, West Virginia versus Environmental Protection Agency, very significant case in the history of our nation, and it's going to be heard again down the road with respect not only to the environment, but other attempts by future administrations, this administration, to exercise its rulemaking authority when it comes to managing its executive authority, things given to it by the Congress, according to the Supreme Court, authorities not giving to it by the Congress here. And so once again, West Virginia versus EPA, a huge case coming out of the Supreme Court just very recently. And the third in this cycle of very important cases from the time right before our last hiatus, before the Independence Day break. This is a case coming out of the state of Washington. Mark called before about the issue of prayer in America. This is that prayer case. We've talked about it previously. This particular case involving whether or not Joseph Kennedy, a former high school football coach in a place called Bremerton, Washington, had a constitutional right to pray on the field after his team's games. The justices deciding in his favor under the First Amendment to the Constitution. A very significant matter, a case issued by the Supreme Court. Right after the break, we're going to talk more about that. Come back, talk with us, WAUK Radio, 844-967-2789, Morning Cannolis in Waukesha. And we're back. This is Morning Cannolis. This is Jim Santel. I'm in the studio here with Connor, my producer. We're at WAUK Radio, the Shaw in downtown Waukesha, 540 AM, 101.1 FM, 844-967-2789. Also taking your calls. Appreciate your comments, your thoughts, and your questions. Right before the break, we're chatting about another one of these very significant cases coming out in the final days of the 2021-2022 term of our United States Supreme Court. This case is Kennedy versus Bremerton School District, coming out of the state of Washington. The question, as I posed it right before the break, was whether or not a football coach in a public school setting has a constitutional right to pray at the 50-yard line after his team's games, presumably in the view of everyone else who's attending the game, also inviting perhaps some inquiry about the extent to which the other football players felt this was a part of their regular team effort or whether they were compelled to do this. Lots of issues related to the circumstances of that. The Supreme Court, in a 6-3 ruling, sides once again in favor of the faith-based interest and sides in favor of Coach Kennedy. The three liberal justices are in dissent. Neil Gorsuch, writing for the majority, said that prayers of the coach were protected by the First Amendment, and the school district, the Bremerton School District, had erred in suspending him for refusing to stop doing that and ending that practice. Gorsuch says this in this major Supreme Court case: respect for religious expressions is indispensable to life in a free and diverse republic. whether those expressions take place in a sanctuary or on a field. He does not draw a distinction between in school and out of school, and whether they manifest through the spoken word or a bowed head, he writes. And so a very significant finding by him. You may recall that, as we said earlier in this very term in Carson versus Macon, the United States Supreme Court had also handed the religious views, a religious posture, another victory in this case involving Maine and permitting parents of students who are attending religious schools to make access to public monies for their religious education. This case, once again, Kennedy versus Bremerton, another in that line of cases that we have seen before. We know from a previous term that the court had also unanimously held in favor of a Christian group that sought to raise its flag in front of Boston City Hall, that they have the right to have that flag waved there, and also with only one dissent, that a death row inmate who sought his pastor's touch in the execution chamber, likewise, as we chatted right before the break, that case, Ramirez versus Collier, likewise, an affirmation of the exercise of religious freedom by the United States Supreme Court. Needless to say, again, we've got dissents in this case, Kennedy versus Bremerton. A lot of disagreement there out there in the community, in the nation generally. Justice Sonia Sotomayor says the majority has gone astray by prioritizing the religious rights of a school district over those of his students who could feel pressure to take part in religious activities. She says, in doing so, the court sets us further down this perilous path, enforcing states to entangle themselves with religion, with all of our rights hanging in the balance. Kennedy versus Bremerton, again, pitting the rights of government workers to free speech and the free exercise of their faith under the Constitution's prohibition of government endorsement of religion and the ability to regulate speech in the workplace. Those things plainly at odds here. The United States Supreme Court rules in favor of resolving that tension in favor of the religious perspective. Kennedy had served as an assistant coach at a public high school in Bremerton. For 8 years, apparently, he routinely offered prayers after games. According to some of the factual information predicating this case, students often joining him. Also led and participated in some prayers in the locker room, a practice that he had later abandoned, according to the record in this matter. Lots to unpack here. I'm very much aware that in the last 60 years or so, the Supreme Court has almost uniformly rejected the notion of obligatory prayer in schools, at least when it was officially required or part of a formal ceremony like that of a high school graduation. Certainly teachers standing up in front of a class, inviting prayer under any faith, prohibited by the Supreme Court. And as late as 2000, just about 22 years or so ago, the court had ruled that organized prayers led by students at a high school football game violated the First Amendment's prohibition of government establishment of religion. And so we've got, if not a reversal, at least a significant change in the drift here of our understanding of the First Amendment and religious liberties, in this case called Kennedy versus Bremerton School District, decided very recently, June 27th, by a 6-3 majority of the United States Supreme Court. Again, a religious case. We've got yet one more coming up later in our discussion here this morning on Morning Cannolis, where we're also taking your phone calls at 844-967-2789. And then we're also going to chat about another significant case coming out of the Supreme Court. This one having to do with the capacity of prosecutors to prosecute cases specifically in the state of Oklahoma, but having implications beyond that. Many of you may recall that in a case called McGirt versus Oklahoma, a 2020 decision just a couple of years ago, the United States Supreme Court had decided in a, again, very important case written by, again, Justice Gorsuch, 5-4 decision, that Native Americans who commit crimes on the reservations there in Oklahoma cannot be prosecuted by state or local law enforcement, and instead must be prosecuted, if at all, by tribal or federal courts. A very big ruling in McGirt a couple of years ago, basically finding that a large portion of the state of Oklahoma is in fact a Native American Indian reservation pursuant to some treaties in the late 19th century. A great affirmation of those treaties. Justice Gorsuch at the time saying a treaty is a treaty, it means what it says, and it says what it means. Well, since that time, the state of Oklahoma, a fair amount of confusion, one could legitimately say, a fair amount of discord about the authorities of tribal courts, of non-Indians, of Indians in Oklahoma, the circumstances under which they can be prosecuted on Indian territory, in non-Indian territory, and an awful lot of advocacy in the courts about straightening out, if you will, some of the implications of McGirt. And so very recently, again, in this case, coming out of Oklahoma, the United States Supreme Court narrowed the sweep of that 2020 decision and says that much of eastern Oklahoma that falls within the Indian reservation, nonetheless, state authorities can in fact prosecute non-Indians who commit crimes against Indians on Indian territory. That's not easy to understand. It has to do with a lot of jurisdictional issues and challenges there. But again, this notion that the state authorities do in fact have the capacity to prosecute non-Indians who commit crimes against Indians on Indian territory. Neil Gorsuch wrote that in many ways, again, needless to say, he is opposed to this most recent opinion coming out of the Supreme Court. He is opposed to it. He says, that what we're doing is we're turning this back. He says that the court should not be taken in by the media hoopla that is attending this response to McGirt. He calls it a litigation campaign. And he said that many of those efforts to try to turn back McGirt sought to portray reservations in Oklahoma as lawless dystopias. That's coming from Justice Gorsuch in his dissent, in this case coming out of Oklahoma. And so we've got that, again, having to do with this very important matter in Oklahoma and the decisions about authorities with respect to Indian country and the authorities of both state and federal authorities to prosecute in that particular venue. And so, again, a very significant case coming out of the Supreme Court just this past term, writing for the majority. Needless to say, the court finds that the decision in McGirt should in fact be perhaps narrowed more certainly to permit some prosecutions to go forward by state and local authorities, again, non-Indians who commit crimes against Indians on Indian territory. No significant matter because it does in fact implicate a lot of relationships between Native American populations in our country, not just in Oklahoma, but also throughout our country. We know well that there are 11 nationally, federally recognized tribes right here in the state of Wisconsin. Again, looking to that case down the road for more direction from the Supreme Court of what this is going to mean now and in the future. We are taking your phone calls as well, 844-967-2789. We're going to break right now. Right after the break, we're going to continue our examination, also take some phone callers. We appreciate your waiting around for those conversations. We're here at WAUK Radio. This is Morning Cannolis, the Shaw in Waukesha.
Try and change.
And we're back. This is Morning Cannolis, a sampling of the news desserts of the week. We're talking this morning, the last in our series of discussions about Supreme Court cases, recent, compelling, important. Right before the break, we were talking about everything from religion to abortion to guns and many other issues. And just as we were going from the first hour to the second hour, I was talking about this case called Oklahoma versus Castro Huerta. There's a case in which the Supreme Court, after finding previously that much of Oklahoma falls within an Indian reservation, very recently the court rules that state authorities can in fact prosecute non-Indians who commit crimes against Indians on those very reservations. Justice Gorsuch joining the liberal bloc of the Supreme Court in a 5-4 in dissent, but a 5-4 ruling by the majority that permits prosecutions of non-Indians on Indian lands for those kinds of offenses. And so, once again, Oklahoma versus Castro Huerta. We are taking your phone calls this morning, and we've got a number of you. Thank you for your time and waiting for our discussion this morning. Let's first go to Dick from Madison. Dick, good morning to you. What's your comment or thought?
Well, it's a little off the topic. It's about yesterday's testimony from the White House Legal Counsel.
All right.
Was that a one and done, or I got a question in that, you know how the previous gal came on, Hutchinson?
Yes.
After she had done this same type of testimony? And it really buttressed the whole thing to see her live. I guess what I'm asking, this guy spoke to them for over 7 hours yesterday. I think he's probably got some interesting stuff to see that maybe should be seen the same way we saw Hutchinson, or was that just a one and done?
No, I good. Appreciate your comment. And actually, we're going to be chatting a lot more about that throughout this coming week. I'm going to be back on Tuesday to stand in for Mike and Don. We're chatting about that because, obviously, the January 6th committee meeting at least twice this coming week, including about 9 o'clock on Tuesday and then some primetime program on Thursday. You're talking about Pat Cipollone, who used to be the White House counsel under the Trump administration. He did appear yesterday behind closed doors. And on the record, we're taking this transcript, testimony before the committee, playing the fact that he's talking for 8 hours means that he is talking. He's giving them some information, not invoking privileges, not in any way stopping the conversation from going forward. Fully anticipate that sometime very soon we will see the results of that interview, perhaps as soon as this week. Certainly a major event in the committee's review of what happened on January 6th. Appreciate very much the call, Dick, this morning. Let's also then talk with Joe. Joe, you're also from Madison. Glad to chat with you again this morning.
I'm very interested in your response to the issue of a coach going for prayer at the 50-yard line on school property, and that the Supreme Court has ruled this exercise of religious freedom under First Amendment holds in both, as you use the language, in school and outside of school. And I'm really curious about how you see this proceeding when it is religions who are not Christian. I just want to give you a couple examples and hear what your reaction might be to that. Let's take the case of Native Americans, the Bad River Band of the Ojibwe Nation in northern Wisconsin. If they choose to have prayer that is of drumming circle and the use of tobacco, which is very important in their religion, can we envision a case in which the coach there is able to use those two items as part of his prayer in leading his students? And what would be the reaction of those parents of Christian children, Jewish children, atheist children to that? Or let's take another. There's an increase in the U.S. military of service people who are claiming membership legitimately in the Norse religions. And, based on the old Vikings, there's a big interest in that. And indeed, in Arlington Cemetery, those service members who have died can claim to have the symbol of the hammer of Thor on their gravestone. The U.S. government realizes this is a real religion. So if we have an ex-service member who is a football coach in, let's say, Antigo, Wisconsin, who wants to offer the prayers of his religion, which is the Norse religion. How does that go? How does that go in terms of other children who are around them who don't follow the Norse religion or who don't follow the Native American religion? I would love to hear how this is going to play out in modern life.
Joe, as always, your thoughts insightful and incisive. This is a great challenge going forward, right? And as I said before the break, I think most people look at Bremerton as being, if not a break, it certainly is a drifting from this previous clear delineation between what happens in schools, what happens with school children, not having an endorsement by a school district, in this case understood as the government, an official public entity, not doing that and imposing upon students who may in fact be of diverse religions. That's your point, whether you're a member of the Ojibwa tribe and or affiliated in some way with a Norse religious belief. That's the wonder and the joy of America. But it also, the whole concept here is long envisioned that we do not bring those things into classrooms. We do not make them a part of our public education. Here, plainly, the Supreme Court is permitting that to go ahead. And I think, Joe, the point of your very good examples, both with respect to Native American tribes, Norse religions, there are many, many others you can think of, where it's getting blurred, right? And frankly, I think it's one of those situations where because of the impact of this case, I think legitimately school districts around the country are going to be facing, as the new school year begins, lots of concerns, lots of challenges, lots of issues raised by parents, raised by students who now want to bring prayer back into the schools, advocating, if you will, for their own faith beliefs. That's always been contrary to our national history. And so I think the point that you make here, really more the head-scratching point about where do we go from here. I think the Supreme Court could have gone in an opposite direction, simply said, you know what, Coach, you can, in fact, you can pray individually. You can't do it with the entire team. You can't do it in this official setting, which is the end of the football game. You can't do it in this very public venue that does partake, if you will, of a classroom, if you will. It's out in the open, I know, but it's a very official, sort of institutionalized situation. Simply have the prayer in the privacy of your own home, in the privacy of your own park, and not have that imprimatur of a government entity on that. That was a distinction was always made. Now more and more, as you've indicated, Joe, as the Supreme Court case in Bremerton also reflects, we've got a messy situation. It has been blurred. And your question, which I take will be rhetorical, about what happens next. What about these other religions who also now want to pray, want to exercise their faiths inside a public school, inside a governmental institutions? What do we do with that? And so I appreciate so much the call, the observation, Joe. I think it's right on the money. And finally, we've got Paul also calling in from Madison. Paul, what's your thought or comment this morning on Morning Cannolis?
Well, I've got a question about our Supreme Court here in Wisconsin.
Okay.
If the left-leaning judge wins in February, I believe the election is, can the gerrymandering issue be brought up again?
So, Paul, your inquiry is about the upcoming election for the Supreme Court here in the state of Wisconsin. As you know, 7 members of the Supreme Court. We've got a race already underway for that seat. A very important race, undeniably, and I think that's what your question goes to. Your question is whether or not the issue of gerrymandering can be brought up again. The answer is cases are before the Supreme Court when there is, in fact, a challenge in courts. And so if there's a case in controversy, if there is a challenge between two parties, presumably initially beginning at a lower court level, going up to an appeals court, and then ultimately coming up to a Supreme Court, could a court revisit past decisions? Absolutely. Absolutely it could. State Supreme Court can do that. Again, if the case is properly in front of it, if there's been some record, if you will, at the lower court levels, there certainly could be a review, a reconsideration of past cases. We saw that at the United States Supreme Court not too long ago when, as we said at the start of our program this morning, in this case called Dobbs versus Jackson Women's Health we saw the reversal of 49 and a half years of precedent. So that principle, the answer to your question is yes, that could happen, requires a case to be before the Supreme Court, whether it's the state of Wisconsin on gerrymandering, other issues before the United States Supreme Court. But cases always come up and are decided by judges when parties bring them to their attention. So appreciate that comment, that observation about civics in America. Paul, thanks for your call this morning. We're talking again about other Supreme Court cases that have been decided recently by our United States Supreme Court. Let's talk about two more of those that are also significant on its docket, and both of these relevant. A lot of comments this morning and lots of thoughts this morning about religion in America. Joe called in and proposed some concerns, some issues, some challenges as we go forward in the wake of Bremerton and the prayer case. There's another case that's also out there called Nance versus Ward. Nance versus Ward. And again, it kind of fell under the radar, but it falls, again, in the category of what do we do in connection with religion inside our corrections system. Here's how the case comes about. An inmate named Michael Nance is arguing that his constitutional right to be spared from cruel and unusual punishment, which is under the 8th Amendment of the Constitution, would be violated if he were to be put to death by lethal injection. He is on death row, and the plan is to put him to death, to execute him by lethal injection. He maintains that his veins in his body would be compromised by that physically. The law basically is that inmates are often permitted to identify some alternatives, and Mr. Nance proposed a firing squad as a method of terminating his life by the state. Officials in Georgia, where this case comes about, he says could in fact adopt that as opposed to the injection. And the case in Nance versus Ward is whether or not Nance could sue under the civil rights law. Justice Kagan, writing for the majority, says in fact that he should be able, writing for the dissent rather, says that he should be able to do that. And we'll talk more about that case right after the coming break here on Morning Cannolis, WAUK Radio, The Shaw in downtown Waukesha, Wisconsin. And we're back. This is Morning Cannolis, sampling the news desserts of the week. We're chatting this morning, as we have been in previous discussions, about the United States Supreme Court. And right before the break, we're talking about this case called Nance versus Ward. We have a death row inmate in the state of Georgia who is facing the death penalty, and he is challenging the method of his execution. The state is going to put him to death by lethal injection, and he maintains with some good, credible medical authority that his veins will be compromised by that. And so instead, he is proposing, as grisly as this once again sounds, that he be executed by firing squad. And the question is whether or not he can sue the state of Georgia under the civil rights laws of our nation to compel the state of Georgia to execute him in the manner of his choosing. Justice Kagan did in fact write for the majority, not the dissent. The majority in this case, a 5-4 majority. She says the prisoner here is not challenging his death sentence. He is taking the validity of that sentence as a given. He knows he is going to be put to death. She says, and he is providing the state with a veritable blueprint for carrying the death sentence out. If the inmate, she goes on to write, obtains his requested relief, it is because he has persuaded a court the state should readily adopt and pursue his proposal in the manner of his execution. So again, not affirming the rightness or wrongness of the method itself, but affirming the capacity of Mr. Nance to sue in state court in Georgia to compel the corrections officials there to put him to death by the manner of his own selection, and that is firing squad. Again, a grisly, a dark case factually, but an important case just because it reaffirms the civil rights that all of us have, even to the time of our death. Dissent, Justice Barrett, writing on behalf of Justice Thomas and Alito and Gorsuch, says that Mr. Nance should have been required to file a habeas corpus challenge, a different procedural mechanism. She is not happy with the manner in which this case came to the Supreme Court and could not use the civil rights laws because as a practical matter, he was seeking to thwart his execution entirely. She sees this as a way of getting around the execution completely. Goes on to say the court is looking too far down the road. This is Justice Barrett writing for the dissent, suggesting that Georgia's potential adoption of the firing squad was speculation. In my view, she says, the consequences of the relief that a prisoner seeks depends on state law as it currently exists. And therefore, she would go in the opposite direction, not give him this right under the federal civil rights laws to petition in the state court for the manner of his execution. Fascinating and grisly and dark at the same time, but nonetheless a major case in connection with religion, if you will, the manner of his somewhat coming from his own religious beliefs, but certainly his own medical beliefs as well. And as we've seen, a couple of cases here coming out of death row in America. A second case also decided virtually at the same time, departing only partly from the criminal venue, and again in the civil arena, the Supreme Court ruling that police officers may not be sued under the same federal civil rights laws for failing to administer the Miranda warnings. The 1966 decision, I suspect many of our listeners, if not all of you, recall this well, the Miranda decision, the kinds of things that a police officer, law enforcement is obliged to tell you at the time of arrest, if in fact any of the statements that follow the providing of those Miranda rights are to be used in court against you. And so in this particular case, coming out of a case called Vega versus Tecco, T-E-K-O-H. Mr. Tecco was a hospital attendant who was accused of sexually abusing and immobilizing a patient receiving an emergency MRI scan. He was questioned at length by law enforcement by an officer named Carlos Vega, who was a deputy in the Los Angeles Police Department. The two men, during the course of this trial, the factual development of the case differed significantly about the nature of that questioning, exactly what happened, how did this come about. But there was no dispute that Mr. Vega did not give the Miranda warnings to Mr. Tecco. Needless to say, the result is that this case comes to the Supreme Court. Mr. Tecco does sign a confession admitting to the assault, and a state court judge, lower court, not the Supreme Court, admits that confession into evidence. And in the wake of all of that, in the state court, the jury acquits Mr. Tecco, acquits him of the offense conduct, even though the confession that he gave is admitted by the state court judge presiding over that trial. And so Mr. Tecco, even though he's been exonerated, he has been found not guilty in the state court, turns around, he does file a lawsuit against Mr. Vega, the fellow who failed to administer his Miranda rights under the civil rights law. That civil rights law is Section 1983. We talk about that a lot in the civil rights venues. And that law allows citizens to sue state officials, including police or other law enforcement folks, over violations of constitutional rights. So the question is that Mr. Tecco raises is whether or not this constitutional right, this right that he maintains that he has to be told his Miranda rights and the abridging of it by this law enforcement officer entitles him to damages under the civil rights law. And Justice Alito, writing for the majority in this case, again coming out of the United States Supreme Court just very recently, says that the remedy for a violation of the Miranda rights was an exclusion of the defendant's statements at their criminal trial. That's the exclusive remedy that's there. He says the decision had not established the sort of constitutional right that could be vindicated by a lawsuit under Section 1983, basically telling Mr. Tecco that he is out of luck, does not have the capacity to sue for what Mr. Tecco perceives to be a violation of his constitutional right. Alito goes on to say, on behalf of the majority, that Miranda rights, he acknowledges that they have constitutional roots, but he says a violation of Miranda does not necessarily constitute a violation of the Constitution, makes a distinction between those two things. Miranda, he says, rests on a pragmatic judgment about what is needed to stop the violation at trial of the Fifth Amendment right against compelled self-incrimination. That prophylactic purpose, Alito writes, is served by the suppression of a trial of those statements obtained in violation of Miranda. And so again, an affirmation in the civil setting of Miranda as this right that requires suppression, but the Supreme Court saying it doesn't rise to the level of a constitutional right pursuant to which you can sue under Section 1983. Right after the break, we'll talk about Justice Kagan's response to that, and then go into our final segment talking about what's next on the Supreme Court docket in its 2022-2023 term. A number of different cases also raising issues important to America. That right after the break here on the Shaw in Waukesha, 540 AM, 101 FM.
We take from each other and give nothing at all. Well, it's a doggone shame, but never too late for change. So if your love runs low, just reach out and call his name. His name. I'ma be there.
Is acquitted. He is found not guilty before a trial that acquits him of the offense conduct, assault alleged against him. And he turns around and he does, in fact, sue the law enforcement officer who failed to give him his Miranda rights during the course of the investigation of this. And case makes it to the United States Supreme Court on this Section 1983 case that Mr. Tecco has brought. And the United States Supreme Court, by majority, says, nope, you do not have a cause of action under Section 1983. Justice Alito, writing on behalf of the majority, saying that this is not a constitutional right that you have. Rather, it's simply a matter of being vindicated, if you will, in the lower court. A suppression of your admission, of your confession, as the appropriate remedy, does not rise to the level of constitutional dimension. And that's Justice Alito on behalf of the majority. Justice Kagan, joined by the regular group of affiliates that she has, associates on the Supreme Court, says that the Supreme Court has repeatedly, emphatically said that Miranda has established a constitutional right. She says that Justice Alito was just plain wrong on his interpretation of this. That means, in connection with Mr. Tecco's case, that officials violating must be subject to lawsuits under Section 1983. Justice Kagan, again, contrary to what Justice Alito says, goes on to say this. Today, the court strips individuals of the ability to seek a remedy for violations of the right recorded and recognized in our Miranda decision. The majority observes that defendants may still seek the suppression at trial of statements obtained in violation of Miranda's procedures. But sometimes, again, this is Justice Kagan writing in dissent, such a statement will not be suppressed. And sometimes, as a result, a defendant will be wrongly convicted and spend years in prison. He may succeed on appeal or in habeas in getting the conviction reversed, but then what remedy does he have for all the harm he has suffered? Again, playing out a possible scenario, even in the wake of a conviction, if in fact Miranda was improperly invoked or not invoked at all. And so we've got plainly a disagreement among members of the Supreme Court, as we have in many of these other cases, that in Vega versus Tecco, and a further exposition about the nature of Miranda rights in America in 2022 and beyond. And so that begins to conclude our arc, this 5-show arc of Supreme Court cases from this past term. Very much appreciate all of your comments, your questions. You're listening in to our discussion about many, many important things ranging across the political landscape, the geographic landscape in various areas of our life. We know that the Supreme Court is going to be reconvening again reconvening again in the first Monday of October. Right now, actually, the term continues. We know Justice Ketanji Brown Jackson sworn in right after Justice Breyer cleaned out his locker and has now moved on to retirement and some other good things in his life. Justice Ketanji Brown Jackson joins the court now as the 9th member of the Supreme Court, taking the place of Justice Breyer, and she will be there in early October when the court reconvenes for the 2022-2023 term of the court, including its taking up of a number of important cases yet already identified for consideration by the Supreme Court. So let's talk about some of those. Race-based admissions, it is back. The issue is back once again. Listeners, you may recall that for years, universities, colleges in our nation, right here in Wisconsin, throughout the Midwest, have been able to take race into account in their admissions process, their decision-making process about who will be admitted and who will not be. And the Supreme Court has affirmed that in a 2003 decision. Well, the current court in this term agreed to hear in the next term a challenge to that. Specifically admissions practices at Harvard College and also the University of North Carolina. Harvard College, University of North Carolina. Case will almost certainly bear the names of those universities. A special interest group called Students for Fair Admissions has accused the folks at Harvard of favoring Black and Hispanic applicants over Asian Americans. Okay, so that's the basis for the lawsuit at the lower courts. The president of Harvard has said that eliminating race as a factor in making decisions about who gets in and who does not get in would make it much more challenging for the school to create a diverse student body. That's his response to this allegation by the Students for Fair Admissions about the way in which Harvard is accepting or not accepting students. Similarly, in the North Carolina case, a like statement by the university advocating that in order to establish, to create, to maintain a diverse population of students, we need that capacity to look at race as one of many factors among a group of factors to be taken into account by an admissions team in deciding whether or not a particular student will be admitted. North Carolina case, interesting, the Supreme Court plucked that one up even before a trial judge's decision and brought it to the appellate level. A lot of issues there related again to the previous decision, 2003. Will that be overruled? What does that look like? What about race when it comes to admissions in America in 2022, 2023? It's coming back. It's coming back once again. And again, speaking about issues revisited, LGBTQ rights, again, going to be on the docket of the next Supreme Court term. The court's going to hear an appeal from a case that's going to sound awfully familiar, again, coming out of the state of Colorado. This one has to do with an appeal from a website web designer. She provides websites for people who are getting married. And she says she is refusing to create web pages for same-sex couples because she says doing so will be at odds with her faith. And again, she is brought into court. The matter comes to the court on the basis that she is in violation of the Colorado law that prohibits exactly that kind of discrimination against the LGBTQIA community. It sounds an awful lot, does it not, like the 2018 case, this Baker case. You may recall justices sided with the Colorado Baker, not on the substance, but basically returned the case to the Colorado courts on the basis that the administrative process hadn't treated him well, had not given him his full day in court, so didn't really decide the case, but sent it back, and a victory at the time for the Colorado Baker, who likewise had refused to bake a cake for a same-sex couple. Well, this time again, coming out of Colorado, it's a website designer, and her name is Lori Smith, Lorie Smith. She's challenging a state law that prohibits businesses from discriminating on a variety of factors, including sexual orientation, just like the previous case. She lost the case on appeal, and she's arguing the law, the state law, the Colorado law, infringes on her right of free speech because it requires her to communicate messages that, according to her, are at odds with her own faith, not in fact consistent with the kinds of things that she would advocate for under her religion, and kept her from posting a statement that explains her belief on her own website. She's invoked her religious rights, and the justices have indicated in granting what's called certiorari, that they're going to take up the case of whether or not her free speech rights have been infringed by this Colorado law in the specific circumstances of this matter coming out of Colorado. Once again, very similar to the 2018 case. We will hear about the butting up of heads, if you will, between LGBTQIA rights, religious liberties, religious rights, that issue back again before the United States Supreme Court. Yet a third case, again, environment. We talked earlier today about this major EPA case in which the Supreme Court said that the president and executive through the EPA does not have the rulemaking authority to address greenhouse gases, and said in cases where the decision by an agency is big, it's large, it's new, it's novel, only the Congress can do that, and therefore rescinded some Obama-era rules that would have placed restrictions in the interest of addressing climate changes. Basically said that the Obama administration could not go ahead with those. Well, we've got another environmental case coming up. It might be going to be the first case argued on October 3rd, Monday, October 3rd. Involves a couple that had put up a 15-year fight, 15 years, to build a house on property that federal regulators say is protected by wetlands. Ruling in their favor could let developers build more houses without having to get these federal permits, and maybe give companies more flexibility on where they can dispose of pollutants. A 2006 ruling, way back in 2006, left some ambiguity under the Clean Water Act. The question is whether or not that 2006 ruling should be applied. It has to do with wetlands under the Clean Water Act. Justice Scalia concluded that the law covered wetlands only if they have a continuous surface connection to a river, a lake, or a major waterway. Justice Kennedy at the time said, nope, it applies if, in fact, they have a significant nexus to one of those large bodies of water also out there. And so we're going to take another break here. At Morning Cannolis here. We'll get back to that Supreme Court case, and then one final case in our final moments here on Morning Cannolis. This is WAUK Radio, The Shaw in downtown Waukesha, 540 AM, 101 FM. Taking your calls, 844-967-2789.
What am I supposed to think?
You think what you want. I don't care.
Fine. So I think.
And we're back for the final moments of our time together this morning. Morning Cannoli is talking about the United States Supreme Court. Right before the break, I was reviewing some of the cases coming up in the next term of the Supreme Court, beginning in October of this year, 2022 to 2023, mentioning this case having to do with whether or not universities and colleges can consider race in making admissions decisions for its incoming classes. A second case coming out of Colorado, once again, determining whether religious liberties and religious expression and religious freedoms should in fact overcome the rights of the LGBTQIA community to non-discrimination, having to do with this woman who is providing website designs for marrying couples, her decision not to do so for a same-sex couple. How does that jibe with our general perspective in support of the LGBT community and non-discrimination laws, including that right there in Colorado? And right before the break, talking about a third case also on the docket of the Supreme Court involving once again the environment, this one under the Clean Water Act, and having to do with whether the Clean Water Act permits the building of more properties in protected wetlands. I mentioned right before the break that Antonin Scalia, way back in 2006, had drawn a fairly narrow interpretation of the breadth of that law, saying that it covered only wetlands that have a continuous surface connection to a river, a lake, lake or a major waterway. Justice Kennedy, obviously on the court at the time, said, no, the standard applies to wetlands with a significant nexus, a connection somehow to one of those large bodies of water, not a narrow interpretation of the law. The couple in that particular case, that environmental case, is asking the Supreme Court to adopt Scalia's definition, a narrow definition of the Clean Water Act, after an appeals court last year ruled the Clean Water Act governed their property. And so we'll take a look, we'll monitor, we'll hear the oral arguments. Probably that case may be the first one up in October as the new Supreme Court convenes in the fall. Yet one more case coming up also, which we'll chat about. But before we do that, let's take another caller. Kristen, thank you so much for calling in this morning. What's your question or comment here at the WAUK Radio?
Hey, Jim. So I have two questions that are kind of related. One of them is, since when, well, I shouldn't say since when are they going to stop with this, okay, there's a new face on the court, so now we're just going to bring back all the cases that had already been decided, we thought, and just redo this over and over again, when we thought a precedent had been set. And apparently 50 years is not enough for this court to be considered a precedent. So that's the first part. But the second part is with this whole, I don't want to serve some portions of the public. How can they not see the court, the slippery slope here of, okay, you don't have to serve the LGBT community. Then the next person could say, I don't think the races should mix. That's against my religion, so I won't serve anyone but white people. I mean, there's like a million things people could claim as a part of their religion. Where does it all end? I don't understand how the justices could be so stupid.
Where does it all end, Kristen?
My question, Jim.
Very
How
good.
can the justices be so stupid?
Right. And I'm going to leave that portion of it alone and prompt you and others to think about that perhaps offline, Kristen. But appreciate again, more than rhetorical observations you're making. The first one, I'll put the lawyer word to this. This is stare decisis, right? Cases have been decided. In case of Roe versus Wade and Dobbs, the decisis, that's the Latin for decided. We've decided these things. We shouldn't always go back and revisit them, and that's your point, Kristen. Courts can, as I said to an earlier caller, they can revisit things if there's a case in controversy that comes up, and certainly there have been situations. We know the Dred Scott decision a very long time ago in which the Supreme Court basically institutionalized racism. We came back and revisited that, right, and said, no, that's wrong. But you've got to have something of that kind of dimension, right, to go back and revisit these things. And the overall arc of human history, of civil rights history in America has been, as I think your first observation suggests, has been toward increasing rights and increasing the notion that people should have life and liberty and pursuit of happiness. And this notion, again, as you very accurately and articulately described, where, okay, we're not happy with the way the world is, let's get a new case in here again, and let's go in the opposite direction. Let's reverse things just because we can. It's very troubling. It's very troubling to me. I think it's very troubling to many people, regardless of what side of the political aisle you're on. This notion of settled law and things that should, in fact, be understood. I think your point is very, very well taken, and a concern that's out there beyond just what we're hearing today in these recent cases. As to this other matter that you also raise, again, it's coming up again, as I said. It's the LGBTQIA issue. It has legs beyond, as you just indicated, Kristen, far beyond the Colorado circumstance. And maybe it would have been a good thing if the Supreme Court had, back in 2018, had really wrestled with this decision when it came to the cake baker. Masterpiece Cake Makers was the name of the case back then. They didn't. They kind of drop-kicked this and punted on a procedural issue and sent it back for greater development and better treatment of the cake maker himself. So it's back again. And we do have here what seems to be, I don't think it's an irreconcilable situation, but one the Supreme Court's going to have to resolve. And as you said, if it doesn't do it right, if it doesn't do it properly here and acknowledge that there are human beings in America and they have human rights, they have civil rights to enjoy all the liberties of all the rest of us, and regardless of all immutable characteristics, yes, sexual orientation, sexual identity, and race and national origin, disability, ability, familial status, economic status, all those kinds of things, all those immutable characteristics, none of that should be subject to discrimination, right? That's your point. And if, in fact, you open up the door to permit someone to come forward and say, well, my faith, my religion says that I can and should discriminate. I don't like something about who those people are, whether it is their orientation, their gender identity, whether it's about their race, as you said, but it's about their, frankly, another religion, right? Any of those immutable characteristics, those things that make us real and alive. If you do that and you permit religion to basically sanction discrimination, here, it may not be the most catastrophic thing in the world. It has to do with a website, but nonetheless, it stands for a larger principle. If you let people do this kind of thing, discriminate based upon, and I would offer, use religion for the purpose of engaging in discriminatory conduct. Your point, Kristen, is where does it stop? Where do we draw that line? And the Supreme Court has this opportunity now, and again, it will be constituted just as it is right now with the 6-3 split, if you will. Sometimes Justice Roberts, again, finds himself in the middle on these things, but in this particular area, in civil rights, certainly voting rights, he's usually sided with the majority of his other Supreme Court justices. Supreme Court has this opportunity now coming up in this term to hear oral argument and to wrestle with this long festering issue. What does religion mean in America? What does the First Amendment mean? And how does that square with, and can it be squared with, LGBTQIA rights and other rights that are out there? My own view, and I think, Kristen, implicit in your comments, is the view that they can be reconciled. There's nothing about this case coming up that the Supreme Court will impose upon Ms. Smith, something that requires her to deny her own faith. But she can maintain that view. She can maintain whatever her views are, but still provide services, provide opportunities for all customers of all sexual orientations and gender identities in her professional capacity. Nothing about that is irreconcilable with her maintaining her own faith, but nonetheless following the anti-discrimination laws of Colorado and other places. I think that's how you resolve these kinds of things. It may not be satisfactory. As I said, in connection with the other cases we described this morning, the Supreme Court has recently sided in favor of religion in this case called Carson versus Macon. Even something as simple as Ramirez versus Collier, the fellow who's on death row right now, and all these other cases involving Boston, the flag. Undeniably, the majority has said that religion wins. The Chief Justice has often spoken about not discriminating against religious interests. And so we'll see how that plays out in the coming term. Kristen, very much appreciate your comments and your questions this morning. There is yet another case that's out there on the docket. Very, very briefly, Supreme Court announcing very recently it's hearing a case that could radically reshape how federal elections are conducted by giving state legislatures independent power. The doctrine is a thing called the Independent State Legislature Doctrine. Case comes out of North Carolina. It has to do with whether or not the state courts, as folks are saying there, were powerless to act under this doctrine, could not in fact review challenges to voting practices. As we all know, state polling, national polling done by state institutions has to do with the authority of state courts to review what's going on in elections coming up in 2022, certainly 2023, 2024, a major elections case also on the docket. And that concludes our arc of consideration of Supreme Court cases, past and continuing and in the future. It has been my great pleasure to be with you in these 5 arcs. Next week, we take up a whole new arc of cases that have to do with law and government and the aspiration for justice in America. Inviting you to come back. Join us again next week at 9 o'clock at the Shaw here in Waukesha, 540 AM, 101 FM, WAUK Radio. This is Morning Cannolis. I'm Jim Santel. Thank you so much for your time, your interest, your comments, your questions. Be well, be safe, and we'll talk to you again next week.